Okay, so good evening, everyone, and welcome to this series of human rights, of a debate on human rights in Africa, hosted by the Chair of African Legal Studies here at Bayreuth. My name is Toko Kaime, and I'm the chairholder and professor here in the Faculty of Law. And it is my pleasure this evening to welcome an eminent jurist from my home, Justice Professor Redson Kapindu, who has made time to be with us this evening. Before we start, I just would like to share a couple of housekeeping rules. I would like to request that you keep your microphones off, and also in order to preserve bandwidth, especially for our guests around the world, that you keep your videos off unless you are speaking. Professor Kapindu is going to speak for about 30 or so minutes. Then after that, we're going to have a discussion round where we'll take questions from participants. I'd like to ask that you write in the chat your name and also your question or an outline of the question, and then I'm going to invite you to present your question in the order that the requests come in the chat. And with those few words, I would like to invite my colleague Lina to introduce Justice Professor Redson Kapindu to all of us, and to welcome him to this series on human rights. Thank you.
Thank you. I would also like to welcome everyone and briefly introduce our today's speaker, Justice Professor Redson Kapindu. Since 2013, he is judge at the High Court of Malawi. Besides, he works as Associate Professor of Law at the University of Johannesburg and University of Malawi. Previously in his career, he also worked as legal practitioner in the corporate sector and in the public service. His research and litigation interests focus on human rights law, whereby he puts a special emphasis on socioeconomic rights and international law. He absolved his LLB and LLM at the University of Malawi and the University of Pretoria. Furthermore, he holds a diploma in international human rights from Lund University in Sweden and a PhD in human rights law from the University of the Witwatersrand. Today, he's going to talk about human dignity in constitutional adjudication in Malawian courts. Now I would like to hand over to you, Justice Kapindu. The floor is yours.
Can you hear me now? You can hear me now?
Yes.
Oh, all right. Yeah, thank you very much. And I would like to thank all of you for inviting me to come and make a few remarks, if I can call them that, on the subject that I have entitled The Principle of Human Dignity in Constitutional Adjudication in Malawian Courts. Now I must state at the beginning, as I told the chair, that at this stage, the thoughts that I have put together are in their very early stage. So this is what I present to you is an early attempt in my quest to reduce to some form of scholarly systematization the Malawian jurisprudence on the subject of human dignity. I decided to look into dignity in view of its paramount status in human rights law discourse. at this early stage of my research enterprise into this significant area of human rights law, whilst I could find little attempts by Malawian courts to expound substantially on the scope and depth of the principle and right of human dignity, I was able to find a good number of cases where the courts in Malawi have grappled with and applied the principle of dignity. Therefore, I concluded that the enterprise that I wish to engage in is a worthy one. But as a matter of scholarship, there is a conceptual problem that I must state up front. The discussion needs a discernible theoretical framework. And now, in this regard, there wasn't much that I could draw, both from the jurisprudence in Malawi as well as from the literature. So in the first part of the paper, I draw inspiration from scholarly literature as well as South African jurisprudence that has been more robust in providing more extensive analysis of what human dignity entails in our part of the world. After some discussion of this theoretical paradigm of human dignity, I will then proceed to explore specifically how several Malawian cases have dealt with the subject of dignity. Now, I begin by pointing out that dignity is a primordial attribute of the human being. Legal and philosophical literature does not seem to provide a clear definition of the term dignity. However, signals of what human dignity entails are not in short supply. Stu Woman, one of my colleagues at Wits University, takes the view that that dignity entails the recognition of the human as an autonomous moral agent. Again, in the South African case of Government of the Republic of South Africa and others versus Grootboom, Justice Yakub stated that human dignity entails that human beings are required to be treated as human beings. Dignity provides a foundational premise for the recognition of all other rights. It may be described, therefore, in my view, as a meta right or a transcendental right, which is underlain in the Bantu African context by a principle that we call here ubuntu, or ubuntu, as it is variously called in different countries in this region. And I briefly explore this ubuntu concept shortly in this presentation. However, I would like to start by giving a description of how some decisions from the South African Constitutional Court have dealt with the subject of dignity. In the case of Ferreira versus Levin, Justice Ackerman eloquently articulated the essence of human dignity. He stated that human dignity cannot be fully valued or respected unless individuals are able to develop their humanity, their humanness to the full extent of its potential. Each human being, he argues, is uniquely talented. Part of the dignity of every human being is the fact and awareness of this uniqueness of the human being. An individual's human dignity cannot be fully respected or valued unless the individual is permitted to develop his or her unique talents optimally. Human dignity has little value without freedom. For without freedom, he states, personal development and fulfillment are not possible. Without freedom, human dignity is little more than abstraction. Freedom and dignity are inseparably linked. So what do you see from the decision of the Constitutional Court in Ferreira versus Levin is that the judge is saying there is an interplay here between dignity and freedom, in the sense that what justifies the right, the various freedom rights is human dignity, and that if the various freedom rights are not guaranteed, then reciprocally, human dignity is not being respected. The concept of dignity was again clarified in another well-known decision in South Africa of Dawood and another versus Minister of Home Affairs. I am not going to go into detail about that case, save to mention that Justice O'Regan emphasized that the concept of human dignity is central to the functioning of a constitutional democracy. Now, I mentioned that there is a relationship between the concept of dignity, as it is generally understood in the context of international human rights law, and a concept in the African setting, particularly in this region of Africa, that we call ubuntu. So the mainstream conception of human rights on the concept of human dignity is, in our view, consonant with this African philosophical concept of ubuntu. The concept of umuntu or ubuntu was classically dealt with in a famous South African Constitutional Court decision of the State versus Makwanyane and Mchunu. Now, those of you who might be familiar with that case, this is the decision where the Constitutional Court of South Africa outlawed the death penalty. Now, Justice Langa stated in that case that an outstanding feature of Ubuntu is the value that it puts on life and human dignity. The dominant theme of the culture is that the life of another person is at least as valuable as one's own. Respect for the dignity of every person is integral to this concept. Treatment that is cruel, inhuman, or degrading is bereft of Ubuntu. So what the judge was basically saying was that, yes, we have this broader concept that we understand at international law of human dignity, but when we are dealing with this from an African setting, as South Africa is, then we should also appreciate that there is this old concept of Ubuntu that goes centuries back from indigenous human rights law. So what Justice Langa was saying was repeated in different ways eloquently by Justice Mahomed and Justice Mohoro in that case. Now, what the discourse on Ubuntu shows is that the notion of Ubuntu is one that fully encapsulates the principle of human dignity. Ubuntu or Ubuntu, and therefore human dignity, represents an idea of African moral philosophy that lies at the core of the African way of life. Violations of Ubuntu are frowned upon by African societies. This has been so over centuries, as I say. The tragedy, though, of most African societies is that they have not codified these fundamental values of society into their constitutional frameworks, opting instead to simply express themselves within Western understandings of human dignity. This includes my own country of Malawi, that we have not really been systematic and serious about unpacking the underlying indigenous law foundations of our human rights law concept. And that when we view the notion of dignity, we will see that this is no strange concept in the African setting, and that it has always been reflected for centuries in the principle of Ubuntu. Now, the discourse on Ubuntu or Ubuntu, as elaborately expounded in the case of the State versus Makwanya and Mchunu, in my view, provides a serious indictment on the rather unhelpful and ill-informed discourse led by scholars such as Jack Donnelly, who have stated that human rights were foreign to the social systems of pre-colonial African, Native American, and traditional Islamic societies, although these had mechanisms to protect and realize human dignity. Makau wa Mutua, in a carefully thought out critique, has assailed Donnelly's assertions. He correctly describes, in my view, as implausible Jack Donnelly's claim that these traditions in Africa, in Native American societies and traditional Islamic societies, that these traditions could make no normative contribution to the human rights discourse. So what I have just said provides evidence that in fact these societies have had much to offer to the broader global concept of human dignity as we understand it. And after that theoretical grounding, I now go into some of the specific instances of the application of human dignity that I explored from Malawian jurisprudence. An examination of the Constitution of the Republic of Malawi of 1994 shows that the principle and right of human dignity is one of the most, if not the most emphasized concept in the scheme of fundamental human rights that the Malawian Constitution guarantees. The Constitution of Malawi recognizes dignity as one of its fundamental principles. Section 12, subsection D of the Constitution provides that the inherent dignity and worth of each human being, I should have said section 12, subsection 4. It provides that the inherent dignity and worth of each human being requires that the state and all persons must recognize and protect human rights and afford the fullest protection to the rights and views of all individuals, groups, and minorities, whether or not they are entitled to vote. It is clear from this provision that the fundamental principle of dignity is presented as a foundational value that provides a basis for the recognition and protection of all human rights under the Malawian Constitution. It is interesting to note that section 12, subsection 4 is the only provision in the Constitution that recognizes that even minorities have rights under the Malawian Constitution. And these are recognized, protected, and respected on the basis of each person's inherent dignity and worth. Now I will highlight to you a number of instances under various branches of human rights law where courts in Malawi have grappled with this subject of human dignity. Now, the first case that I highlight to you is a case where refugee law was in issue. This is the case of Aden Abdi Haji and 67 others versus the Republic. Now, in this case, what had happened was that a group of asylum seekers from Somalia had been arrested somewhere in the city of Lilongwe. They did not have valid immigration papers for entry into the Republic of Malawi, but it was clear they were coming from Somalia, and at a time when there was still violent conflict in Somalia. The authorities arrested them and they wanted to deport them back to Somalia. The matter then, the short of it is the matter came to the High Court, and the judge there made a number of interesting remarks. The judge referred, Justice Chombo, referred to section 12, subsection D or 4 of the Constitution as a provision that endorses the principles of human rights expressed in international instruments. And in particular, she held that declaring the asylum seekers in that case as illegal immigrants before they were properly assessed as asylum seekers could offend the provisions on human dignity under section 12, subsection 4 of the Constitution. Whilst the judge did not expound as to why she arrived at that conclusion, when one examines the decision, one observes that she underlined with emphasis the words, and I quote, "the fullest protection to the rights and views of all individuals, groups, and minorities, whether or not they are entitled to vote." This conclusion that the judge arrived at demonstrates that Justice Chombo was recognizing that asylum seekers as a group and a minority as persons who were not entitled to vote were still, under the Malawian Constitution, entitled to the fullest protection of their rights on the basis that Section 12, subsection 4 of the Constitution had guaranteed them dignity. The basis for such protection, according to the Constitution, is their inherent dignity and worth. Further, when one has regard to the conception of human dignity and the principle of ubuntu that I have discussed earlier, one can sense that Justice Chombo was applying in practice the idea that human beings are to be treated as human beings, as it was stated in the case, in the Kurupum case. And I must emphasize that she also upheld in that case the customary international law principle of non-refoulement, and in her analysis, she still links even the concept of non-refoulement to the principle of human dignity. The second decision that I want to refer you to is a case called Frederick, Banda versus Demon Malawi Limited. Now, in Frederick Banda, the plaintiff complained that he had been forced to resign from the company. That is, he said that he had been constructively dismissed due to the conduct of the defendant company, which was racially discriminatory. So he argued that he was constructively dismissed because the company was engaging in racial discrimination. Justice Ndovi found in his favor, in Mr. Banda's favor. And the judge found that by violating the plaintiff's right of non-discrimination, the defendant, the company, in turn violated the principle of human dignity, which is inviolable and is firmly guaranteed under Section 19, subsection 1 of the Constitution. So what the case of Frederick Banda versus Demon Malawi Limited shows is the interplay that the judge draws between the principle of dignity and the principle of equality or non-discrimination, as it were. Then in another case, I moved to another subject. So I talked about human dignity under refugee law, and then human dignity vis-a-vis the law on equality or non-discrimination, and then another area of the law where our jurisprudence has dealt with this issue of human dignity relates to the death penalty. In a case called Kafantaini and 5 others versus Attorney General, the question that arose before the High Court sitting as a constitutional court was whether it was constitutional for Section 210 of the Penal Code to provide for the mandatory imposition of the death penalty. So what that means is that once a person was found guilty of murder, the penalty was automatically death. There was no exception. So there was no room for the accused person to address the court on personal factors, for example, in mitigation, so that he or she probably may be given a lesser penalty. When the High Court considered this provision, Section 210 of the Penal Code, the court found that the section was unconstitutional. And one of the most important premises upon which Section 210 of the Constitution, of the Penal Code rather, was found to be unconstitutional was that it violated the principle of dignity under Section 19, subsection 1 of the Constitution. That decision was affirmed by the Malawi Supreme Court of Appeal in another case called Two Boy Jacob versus the Republic. So here we see the principle of dignity being used to outlaw a provision in the Penal Code that made provision for the mandatory imposition of the death penalty. Another area that I want to highlight relates to the rights of persons in detention and also treatment of prisoners. Now, in a case called Lukungwa Ukasha versus Republic, Justice Square was dealing with a rule that here we call the 48-hour rule. So Section 42, subsection 2, paragraph B of the Constitution provides that every person who has been detained, accused of the commission of an offense, has the right to be brought before a court of law within 48 hours from the moment of his or her arrest, so that he or she may be informed of the reasons for, one, his or her detention, and number two, if the detention is being extended, the reasons for his or her further detention. Now, in this case, the Lukungwa Ukasha case, the accused person had been held for a little more than the 48 hours before being brought to court. And Justice Twere, as he then was in the High Court, now he's a Supreme Court judge, he observed that it is important that when we have constitutional provisions guaranteeing rights, such as the 48-hour rule, that they must be scrupulously observed, and that we should not be making allowances even for the slightest departures or violations of those rights. So and then he emphasized that the reason that we must strictly observe this is because of the principle of human dignity that has been guaranteed under Section 19, subsection 1 of the Constitution. So the judge concluded by saying that the remedy for breach of that rule was a release of the accused person. And then we have another case dealing with the issue of treatment of prisoners, and this is the case of Enea versus Republic. Now, in Enea versus Republic, a famous prisoner by the name of Kwajarambi, he was famous here in Malawi, he had been killed by prison warders in detention. And the justification that they provided was that he was misbehaving in prison and that they were trying to discipline him, as it were, and they therefore were claiming immunity from prosecution on the basis that they killed him in the course of their duties. The Supreme Court of Appeal did not have kind words for their defense. It dismissed that kind of defense and emphasized that there was no excuse for their conduct in murdering this prisoner in prison. And the Supreme Court of Appeal emphasized that, you know, paramount among the rights of the late Mr. Arambi was his right to human dignity under Section 19, subsection 1. The principle of dignity has also been invoked in support of both the rights of prisoners as well as social and economic rights. So that's another head. We have a case called Gebo Masangano versus Attorney General. In Gebo Masangano versus Attorney General, prisoners brought a class action where they were challenging the state for harsh prison conditions generally. So they were arguing that they do not have enough ventilation, they are not having enough food, they are not having enough enough space for sleeping, and that the harsh conditions in prison were leading to a number of communicable diseases such as tuberculosis. And they therefore argued that the conduct of the state in not guaranteeing them their rights violated their constitutional rights. And the paramount right that they brought up was the right to human dignity. The High Court, sitting as a constitutional panel, upheld their claims and made a number of directives to the state to comply with in ensuring that the rights, the conditions in prisons were improved. And another thing that is significant about the Masangano case is the court made it very clear that it is not true that socioeconomic rights under our constitutional enterprise are not justiciable. The court made it very clear that socioeconomic rights are justiciable under the Constitution. Another case that I would like to highlight to you is a case that highlighted the interplay between what I call poverty and dignity. This is the case of Maesogwanda versus the state. In Maesogwanda versus the state, what happened was that the accused person had been arrested for an offense called being a rogue and a vagabond. So essentially, under this offense, what the police would do is they would just walk around maybe at night, find people who they think do not have a purpose for finding themselves in town, and basically arrest them, take them to prison, and accuse them of committing an offense. Now the judges in Maesogwanda versus the state, okay, so what happened in that case was that section 184, subsection 1C of the Penal Code that makes provision for that offense was challenged for being unconstitutional. And the High Court found in favor of Mr. Maesogwanda. The High Court said that that provision was inconsistent with section 19 subsection 1 of the Constitution that guarantees the right of human dignity. And the justices in that case, Justice Kalembera and Justice Ntaba in particular, were very clear that in their view, what that offense did was essentially to criminalize poverty, because the people that were always targeted for arrest under that offense were people who were poor. And the judges went as far as exploring the history behind the evolution of that offense from its early sources under English law. And this fortified their conclusion that this is an offense that was essentially meant to criminalize situations of poverty and destitution. They concluded that such a law was inconsistent with the principle of human dignity, and they therefore invalidated that provision. Another area in which the principle of human dignity has found expression is in the area of adoption of children. So we had a case here around 2005, 2006, where some famous global celebrity came seeking to adopt a child. And under Malawian law, there is a clause under the Adoption of Children Act that says that in order for a person to adopt a child, they must be resident in this country. The people that came seeking to adopt this child were obviously not resident in Malawi. So what happened is that the judge explored a number of international law instruments as well as the Constitution. And he highlighted the principle of the best interests of the child. And what he did after that thorough exploration of both international law as well as the Constitution is he found that, what would fortify his conclusion that the principle of the best interest of the child had to be paramount was section 19, subsection 1 of the Constitution that guarantees human dignity. He therefore concluded that insofar as I think it was Section 3 of the Adoption of Children Act had the effect of impeding the best interests of the child, he would hold that the principle of dignity that encapsulated the principle of the best interests of the child trumped that residency requirement. So that is the last bit that I wanted to highlight, and I then go to my concluding remarks that it is evident from the analysis that I have provided to you that although Malawian courts have not been as elaborate as South African courts in defining the essence and the contours of the principle and rights of human dignity under the Constitution of Malawi, they too have treated human dignity as a paramount principle and right, one upon which other rights draw their justification. One upon which the other rights draw their justification. There is a reason I sought to engage in a discussion of the principle of dignity. First is my own firm belief that the principle is a cornerstone of any scheme for the respect, protection, promotion, and fulfillment of fundamental human rights. Second is my view that in Malawi, we have not yet done well in unpacking the foundational principles of the Constitution as laid down under Section 12 of the Constitution and exposing the extent to which these have been practically applied by Malawian courts. So I thought that we can start this conversation by looking at the principle of dignity. From the rather cursory analysis that I have thus far provided, I tentatively draw the conclusion that Malawian courts are fairly liberal and progressive in their understanding and application of the principle and the right of human dignity. The courts have adopted an approach that treats the principle as a meta-right, providing an epistemic basis and a justificatory premise for the vindication of all other fundamental rights. The liberal approach that has been adopted by Malawian courts provides promise, in my view, that the principle will gradually be developed through elaborate definition and exposition as the bedrock upon which our scheme for the advancement of human rights will rest. The heavy reliance, which is observable in this case on South African jurisprudence as a comparator, needs some explanation again. The two constitutions, that is of Malawi and South Africa, in their interim states, were drawn around the same time, between 1993 and 1994. There are a lot of commonalities in these constitutions. An examination of the two constitutions reveals striking similarities, especially in their schemes for the guarantee of fundamental human rights. Thirdly, South African jurisprudence is readily applied by Malawian courts, especially in constitutional cases, and it therefore makes sense to refer to such jurisprudence as signaling what is likely to be the Malawian conception of the principle of dignity. One key takeaway, which I end with, from both the Malawian and South African jurisprudential discourse, is that there is not much emphasis on the indigenous law premises for the principle of human dignity. In the lone case of the state versus Makwanyane that I referred to, this exercise was satisfactorily done with a thorough exposition of the principle of ubuntu under the interim constitution of South Africa. However, this unfortunately ended there. There has not been another case where the Constitutional Court of South Africa has dealt with the principle of ubuntu in similar fashion. This is ostensibly because the principle was dropped from the final text of the Constitution. However, I argue that considering that both the Constitution of Malawi as well as the Constitution of South Africa admit of the application of indigenous law as a clear source of law, there is no reason for the court's silence in further developing this important indigenous human rights law principle of ubuntu. This, therefore, is the message and the core that I wind up this discussion by inviting our courts and indeed our scholars to expound more on the principle of ubuntu as an expression of the broader of the principle of dignity, I should say, not broader. Probably ubuntu is broader than the principle of dignity. But those are my reflections, Prof, and I think I should stop there. I went a little bit over my time. Thank you.
Right, and thanks so much for an insightful discussion of the various cases dealing with the issue of dignity under the Malawi Constitution. There's a couple questions in the chat, and I'm going to kick off our discussion by posing a question, but also inviting some of our participants to join us. I think we are going to take a couple of questions in each turn, and then you can answer these in seriatim. So I wonder the scope of dignity in tough human rights cases. So I'll give the example of the rights of our LGBTIQ brothers and sisters, for whom many rights are refused or denied on the basis of their orientation. I mean, what is the role of this principle in relation to the protection and promotion of their rights, and what should be the role of Malawian courts in expounding the principle of dignity in these particular cases. I see here in the chat that Isabel and Melina and Paul would like to ask questions. So I'll ask Isabel to please state her question. Thank you.
All right, thanks.
Okay, thank you very, very much for your presentation. It was awesome to listen to it. My question would be, you named some constitutional cases that were really, really interesting, but I was wondering if there is a specific role of other courts, especially informal courts, that can also support and defend rights and especially human dignity.
Sorry, you were breaking a bit. Can you come again, please?
Okay, I try.
Yes.
In short, my question is if there is a specific role of informal courts or non-constitutional courts in defending human rights and especially the human dignity.
Okay. Yep, thank you.
Okay, Melina, please go ahead.
Yes, hello. Thank you very much again for this very interesting talk. I'm not a lawyer, so please excuse me if my question is not clear enough, but I was wondering, because you talking about cases in which human dignity was put forward by judges.
Yes.
I was
Yes.
wondering if you have good examples for cases in which human dignity should have been put forward but wasn't. And if you have, if it is possible to compare these cases and see some influencing factors, like this might be the biography of the judge, this might be the topics. This is something I think also Toko Kaime just mentioned, like, for example, the rights in the case of different sexual orientation. Or yeah, maybe also other topics that might occur in court. Thank you.
All right.
Okay, and finally for this round, Paul, if you could please come in.
Thank you very much for your eloquent presentation. I have a comparative law question for you. Because also the German Constitution embodies the notion of human dignity in its first article. However, the Constitutional Court and also the other courts are really careful in utilizing that provision. And it's not really common to rely on that when people bring judicial challenges. Because one is probably always afraid that an overuse the notion of human dignity devalues it or something like that. So I was wondering whether you share such concerns, or would you consider human dignity as a useful tool that one should rely on more often?
All right. So I take those four.
Yes, please go ahead.
Right. Let me begin by the first question on what role the principle of dignity would play before Malawian courts with respect to LGBT IQ rights. One of the challenges of having a judge present is there is always a risk that he will recuse himself from answering a particular question. Now, I can say that I have slight hesitation in addressing that question because I happen to be on a panel of a constitutional case that is dealing with these issues. It therefore makes it a bit tricky for me to start addressing it, lest I seem to be preempting what is likely to be my decision in that case.
Okay.
So if you could... I hope that is understood.
Yes, this is clear. So I think we could. You could share your views in very general terms. Even addressing the issue of the legitimacy of the court's decisions in relation to this principle, but it can be at large. So this is well understood. Thank you.
Right. So look, all I would say is that I have no doubt that in the arguments that we are likely to hear on this matter, the principle of dignity is likely to feature prominently. As I said, I think anything beyond that would be me delving into tricky waters, considering that it would have been a different case if perhaps I was not handling a matter like that. So I will stop at that, I think, on that issue. The second question was what I would consider to be the role of informal courts in defending human dignity. Look, I think that that is a very important question. And it takes me to it takes me to the point that I was raising about African philosophy with regard to human rights. And I talked about the principle of ubuntu. And in most of our informal tribunals, if I can call them that, or informal courts, the courts apply indigenous law. And when you sit down and listen to the principles that they articulate, you will find that the principle of ubuntu, or umuntu as we call it in my country, features very prominently in these informal settings. And to that extent, I will argue, I mean, the only problem, which is one of the things that I said at the beginning, is that we do not seem to systematize, especially on our part, if I am to, when I put on my hat as a scholar, we do not seem to be carefully systematizing these developments and locating them within established human rights law discourse. So my answer is that human dignity as a concept in its various shapes as understood in the African context ought to play, and that it in fact plays a very important role in the settling of disputes at the informal level. It is important that we should be highlighting these things, both on the part of higher courts when the matters present themselves, and bring these out in the form of published scholarly literature. Then I think the other question that was raised was, I have talked about cases where the principle of dignity has been raised or applied in Malawian courts. And the question was whether I can cite instances where the principle ought to have been put forward. A very good question. I didn't set out on that enterprise. But if I could quickly talk about one case, I would highlight a case over which I presided. I think it is safer for me to critique myself and say that there was a case that I handled where, you know, residents in a semi-formal setting in a city that we call Mzuzu came to court seeking relief that they were being forcibly evicted by a public housing agency in this country called the Malawi Housing Corporation. The people that were affected by the decision to evict them affected, according to the applicants, close to 20,000 people in that location. When the matter came before me, what I ended up doing was to make an order that the parties should go and meaningfully engage. Now, meaningful engagement is a special kind of remedy that was developed first, I think, by the South African Constitutional Court, and it is applied in various social and economic rights cases in South Africa. And we thought that it was an appropriate case to call upon the parties, because one was a public body and the decision was affecting thousands of people. And each party, you know, had a reasonable claim to make. And we resolved it that way. I would imagine that this is a case where I ought to have addressed the issue of human dignity as it implicates the enjoyment of socioeconomic rights, such as the right to housing. There is a decision of the African Commission on Human and People's Rights called the SERAC case, where the court looked at the African Charter on Human and People's Rights, found that there was no express guarantee of the right to food, but the court said that when one has regard to the fact that the right to dignity is guaranteed under the Charter, one can read into that a panoply of various social and economic rights, including the right to food. And so the point that I'm making here is that insofar as the issue at play related to housing rights of the people concerned, although the right to housing is not expressly guaranteed under our constitution, probably it is a case where the concept of dignity ought to have been highlighted. And I mentioned the interplay between dignity and poverty. Most of those people were very poor people who probably would not have alternative accommodation if they were evicted, and that implicated human dignity. I can just quickly talk about that case, but I'm sure that there are many cases, not just a number, where if we apply our minds carefully, we may come to the clear conclusion that this and that are matters where the judges would have invoked dignity at play. I think the last question, if I got it right, which was whether one gets the impression that the principle of dignity is perhaps overused, and that if it is overused, it may eventually get us to a situation where we devalue the value that we attach to the principle of dignity. And what are my views about that? My view is yes and no, if I can say that. I would say that there is a principle that we call constitutional avoidance, which we apply in our cases here. So the principle of constitutional avoidance is that we say, if it is possible, that a matter can be resolved without adverting to a constitutional question to settle the dispute, that is the appropriate route that we ought to take. And that we should only bring in a clear application of the Constitution, in which, in our case, more judges are going to sit on the matter, where there are clear questions about the Constitution that arise. And dignity is one such clear constitutional principle. So I would say yes, on the premise that we generally are guided by this principle of constitutional avoidance, that as far as possible, where we can resolve disputes in a manner that does not invoke constitutional provisions, we should do that. But no, in the sense that we also should not get ourselves to a situation where we fail to give litigants appropriate remedies because we are deliberately avoiding the invocation of an important constitutional principle or right such as dignity. So I think it is a delicate balance that ought to be struck. Thank you.
Okay, thank you, Judge, and thanks for this interesting discussion. We are going to follow this case which you are presiding quite closely. There's actually a question here from Lawrence around the same issue. Of course, this question is reads like a yes or no question, but I think he will elaborate when he speaks. So I'm going to invite the next three questions, and then after that we can close. So Lawrence, your question, bearing in mind that the judge has already said that he is presiding over a case where he's dealing with these matters, and so he is not free to. Then thereafter, Mumbanika, if you could ask your question, and then we're going to close this session with a question from Fatuma Silungwe, one of my sisters from Malawi. So, yeah, please, Lawrence.
Hello and good evening to everyone. Unfortunately, I'm on transit. I can't share my screen with you. I hope you can all hear me. So thank you very much, Justice Redson, for sharing wonderful presentation in terms of like Malawian context. I'm Lawrence, I'm here from Malawi, and I'd like to understand, is there a possibility for one who self-identifies as transgender to change their name legally and also their gender marker?
Sorry,
So
yes?
Is there like a provisional law that speaks onto that, a particular law that recognizes transgender people and the bare fact that one can change their name from their best names to a preferred name? Is there a possibility for one to do that in Malawi?
Okay.
Okay, please, our next question. Mumbanika. Okay, I will invite Fatuma to ask her question next.
Thank you, Judge, for a very good presentation. We have learned a lot. I'm speaking from Malawi. My question is, courts in Malawi, they often dwell on the black letter law, and they often avoid theory. So I was wondering, can we anticipate in the future a court that would unpack the principle of ubuntu or umuntu as it applies to Malawian cultural values?
Okay, the first part you were breaking. You said courts tend to stick to black letter law and avoid. Then I didn't hear what you said.
Oh, theory, like
avoid theory. Okay.
Yeah.
Okay. All right. Yeah. Thank you. I think I get the question.
Read this question on behalf of Mumbanika. I think it's some issues with the sound on his part. So the question, Judge, is this. Do you think that the reference to the notion of ubuntu in the court decisions in Malawi have been of any practical relevance? That's the first part of the question. And then the second part of the question is, to what extent the state complied with the court's orders improving the living conditions of people in prison after the Gambi case that you discussed.
All right. So should I take them now?
Yes, please, go ahead.
All right. I think the first question is, again, one that as I indicated at the beginning, I really have to deal with it in a very judicious manner for the reasons that I had already provided. But they are straightforward questions, probably, that one can, I mean, to my knowledge, is there a law that addresses transgender issues? a specific law? To my knowledge, no. The other question, whether there is a law specific that would allow transgender people in Malawi to change their names, again, in terms of specific law that I'm aware of, again, I would say no. But in terms of how these issues would play out if they arose from a constitutional setting, that's something that I am not prepared to go into. The other issue that was raised was that courts in Malawi, and this is a proposition that is being put to me, that we tend to stick to black letter law and avoid theory. And whether I take the view that perhaps in future we will have instances where court will unpack the theory behind concepts like dignity and ubuntu. Look, I take that as an indictment and an observation at the same time from Fatuma. My view is the way that I know my colleagues in the High Court and in the Supreme Court of Appeal is I do not doubt that all of us have what it takes to where the situation is deserving to fully unpack the theory that underlies these concepts. So my answer will be yes. I am hopeful that there will be instances where our courts are going to unpack sufficiently so some of the theoretical underpinnings that underlie these concepts of such as dignity and ubuntu. The other question was, I think, whether the reference to the notion of ubuntu and by Malawian courts has had any practical relevance. Maybe I should clarify that to my knowledge, we have not had Malawian courts that have dealt with the notion of ubuntu. What I mentioned was that I am aware of a lone case in South Africa by the Constitutional Court of South Africa, one of the earliest decisions of the Constitutional Court of South Africa, which was the State versus Magwanyane, the decision where the Constitutional Court outlawed the death penalty. And one of the premises upon which the court arrived at its decision to outlaw the death penalty in that case was on the principle of ubuntu. So if I am asked whether the principle in that setting in South Africa, where it was applied, has had any practical relevance, I would say yes, they no longer have the death penalty in South Africa. So that's practical. It has had practical relevance. It could, of course, be argued. I mean, it was not the only basis upon which the court outlawed the death penalty. The principle of dignity, as we widely understand it, was also used, but the Ubuntu principle was also squarely used. And I would therefore submit that it has had practical relevance in South Africa where it has been applied. In Malawi, I am not aware of any case where any court has expressly invoked the principle of Ubuntu. Then the last question was, to what extent the orders of the court in the case of Gebo Masangano versus Attorney General about the prison conditions, the extent to which those orders have been complied with. I think I can say here with a clear conscience that there has not been compliance. And I think I can stop there. I need not say more. Nothing has improved. If anything, those of us who visit prisons as visiting justices, observe that if anything, some of the conditions have been getting worse. But we hope that there will be some progressive measures taken in the future. But thus far, the conditions are still very harsh, and I have not seen any improvement. So I think that I can say without equivocation. Thank you.
Okay, Judge, with your indulgence, I would like to reopen this. I just noticed that one of my classmates has asked a question, and I think there's a duty on me now to make sure that this question is heard. Pacharo Kaira, please, if you would ask the judge your question.
Hello, can you hear me?
Yes, I can.
Yeah, it's always good to have a classmate who is chairing the session. You get favors. Yeah, thank you so much for your presentation. Written neat. You talked about our judiciary being quite liberal, applying the principle of human dignity, and of course our constitution is also quite liberal. But now my observation is that of the three arms of government, my view is that the executive and parliament are not as liberal, if I may say, in applying the liberal spirit of the constitution. So my question to you is, to what extent would you advise the executive or be for the position of the executive to be a bit more adventurous in being preemptive in a way to apply the principles of human dignity even well before they get to the courts, essentially through law reform and policy adoption. Now, speaking from someone who is from the Ministry of Justice, I see that from where I'm sitting as far as human rights are concerned, there are aspects of human rights which are easy to predict, to say 2-3 years from now, this thing is going to be outlawed. 2 years from now, the court is going to say this on this aspect. But there's been a bit of reluctance from the executive and parliament to look ahead and simply apply the principles of the constitution, specifically human dignity in this case, way before the matter becomes a subject of litigation in the court. So to what extent would you encourage those of us in the executive to be a bit more adventurous in applying this principle way ahead before matters go to court? Thank you.
All right, I thank you, Pacharo, for that interesting and fairly tough question. How would I advise the executive? I should be very careful not to purport to provide advice to the executive, because I'm mindful that I still wear, two hats, that of an academic and that of a judicial officer. I think what our duty as courts is to pronounce the law as it is. And to what extent, as courts, we are prepared to pronounce the law as it is with the clear spirit that underlies the law under the Constitution. I think that Malawian courts have shown again and again that the courts are always prepared to do that. And I believe that the courts will continue to do that, living true to the spirit of the Constitution. From a position of scholarship, I think one reason that I might hypothesize could be the cause for what you call conservativeness on the part of the executive and parliament is that these are political branches of government. and being political branches of government, they are particularly mindful, in my view, about what is likely to be a popular stance to take, which courts don't do. So the position of the courts is simply to, articulate and pronounce the law as it is. The courts are not there to live to the tune of popular public opinion. They are simply there to pronounce what the law says as it is. So I would imagine that, as I say, this is just from a scholarly mind, that most probably, in my view, the reason for what you call executive conservativeness or parliamentary conservativeness in dealing with some of these issues, and therefore not engaging in preemptive decisions to address some of those clearly predictable issues. I think the reasons lie in the fact that these political branches of government, elected representatives of the people, and I think in their minds, what preoccupies their minds, and they cannot be faulted for doing so, is for them to say, what are our constituencies out there saying? And they cannot be faulted for doing so. But I think that would probably be the reason. On the part of the courts, and again, the courts, rightly so, it is not their province to act as if they are representatives of people. Their role is to interpret and apply the law as it is, and I think that's what the courts do. And given the nature of the Constitution, a faithful reading of the Constitution might indeed lead one to predict what some of the decisions would be. I hope I'm answering your question.
Yeah, I think it's cool. Yeah.
Yes.
Thank you.
Thank you.
Oh, okay, so thank you for your engagement, Judge, and I think this is a good moment to close the formal part of our discussions, and I just want to express how grateful we all are that you were able to join us this evening, and I'll let us continue perhaps a little bit more informally. I have received a number of texts on my phone, about some additional questions that I think we can continue to discuss. But I just wanted to close by saying thank you so much. And those that would like to leave the presentation now, I think that is perfectly okay. We're going to continue for another 5 minutes or so, perhaps dealing with a couple of informal questions, but also points of connection. Okay. So I'll start by reading a question that was sent to me by text by one of the participants here, and it relates to the wider question of human dignity. And the question is, if indigenous religions and their notion of human dignity have any room in a secular court, as you described. Your reflection on this is even more interesting because of the concept of ubuntu. I mean, so I think the question really addresses this issue of the source of inspiration for this legal principle. What are the possibilities of drawing inspiration from indigenous religions, particularly their notions of their ancestors and human dignity.
Well, I want to understand it, especially the religious aspect, because I didn't address it. What is that about again?
Okay, so like African indigenous religions will have their own expressions of
the sources of.
Yes, so I think the question, I mean, I'm interpreting the question.
Yes.
And the question addresses the source of inspiration for this legal principle. Could we draw the inspiration, not just from other legal expressions of dignity, as we have seen from the South African court, but also from African religions, for example? Yes.
Well, I think the answer would be yes. Look, the issue, the question of sources of the concept of dignity is something that I also explored. Probably I didn't talk about it because I still had to proceed within time. But in my exploration, I was pointing out that there are, at least 3 conceptions of the sources of dignity. So one conception is that the concept of dignity, or ubuntu, has a divine source. Okay, so the societies that have different conceptions of the deity, right?
Yes.
They posit that when we say that one has inherent dignity, that inherent dignity derives from an external higher source, which is the deity, and so I would say yes, there is a sense in which one would agree that some of those indigenous conceptions of the notion of ubuntu would be drawn from conceptions of the divine. It takes me to a fundamental debate for those that have explored the history of the adoption of the Universal Declaration of Human Rights. That when Article 1 of the Universal Declaration of Human Rights was being adopted, now I can't remember the exact language, but I think it says that all humans are endowed with dignity and rights, and that they must treat each other in a spirit of brotherhood. I think that's the sense that you get from that article. And the surrounding history around it is that the framers had heated debates. So there were people who were saying we must expressly mention that all humans are endowed by God with reason and conscience. And others were saying, no, you don't understand. The endowing is actually coming from within themselves. Because as humans, we are sentient, and that we have a sense of reason and autonomy, and in the Kantian sense, and this is what endows us with dignity. Okay, so ultimately, maybe to cut the story short, they concluded that we should simply say that all humans are endowed with dignity. And everyone would decide for themselves what they read into that. So for me, when I read the clause that says all humans are endowed with dignity, I will say, I know the endowing source. It's God, the Almighty. Another one will look at the same and they will say, no, I know the endowing agent. it is X and Y. And so that was like a consensus. And I think this is how I would approach a question like this, to say, yes, we may have different societies that have different conceptions of what are the sources of this dignity that we are talking about, but what is paramount is that dignity is guaranteed. What the source is probably relevant for intellectual discursive purposes, but for practical purposes now, me, for example, sitting as a judge, I will say it doesn't really matter. What matters most is, do we have a legal guarantee?
Yes. Okay. All right. JB, you indicated you had a question. Do you want to turn your mic on and ask your question, please?
Hello, can you hear me?
Yes.
Yes.
Okay, so this is my question. First of all, thank you for your good presentation. It was really interesting to note how the concept of human dignity can touch various aspects of human life. But my question is, a correlation between the principle of human dignity and the principle of ubuntu or umuntu can be a bit dangerous, particularly in African cultural settings that observe certain practices that are also against human rights and are still embraced cultural practices such as female genital mutilation, or practices where women are denied of certain rights just because of their gender. So I wanted to know, what is your opinion on this perception?
Right. Look, my quick response would be that I am yet to find any form of discussion where the principle of Ubuntu has been used to justify bad practices such as FGM or the denial of women's rights, as you have said. But I would submit that I think a proper understanding of Ubuntu, which is about humaneness, which is about love, which is about reciprocal treatment of each other as equals, would in fact lead us to an elimination of these dangerous practices if we are faithful to them. You see, when you examine the history of human rights per se, you will find that whilst, for instance, the notion of human dignity has been recognized probably for over a couple of centuries, during those years, whilst we had an understanding of dignity, you had slavery, you had women not having the vote, women being treated as minors, black people being, cruelly denied a wide spectrum of rights at a time when societies were saying, we value human dignity. Does that mean that there was something wrong with human dignity and it could be applied to justify racial discrimination or discrimination against women? I think not. What it entailed was that we had societies that deliberately did not want to give a faithful interpretation and application of the notion of dignity, and this is what led to all these violations. I would therefore correlatively, if I am to use that term, apply it to the situation that you raise. That similarly, it is undeniable that in many African societies, probably all African societies, that you have different forms of subjugation of women and consigning them to the margins of society. But this happens because of, in my view, deliberate misapplication of good concepts such as Ubuntu. But if we had good and faithful applications of these important principles, we should be getting to a more just society. So I will say that no, we should not sense danger in advocating and advancing the application of a good principle such as Ubuntu. We should embrace it and properly apply it in our societies to advance the cause for human rights for all.
Okay, thank you, Judge. Before I perhaps ask what will be my last set of questions, I just wanted to mention that Ms. Sache, whom you have spoken with before, is also amongst the participants. Diana, do you want to say hello to the judge?
Sorry. Hi. I was a little, ill-prepared for this, but thank you for the presentation, Justice Redson Kapindu. I do have several questions, but perhaps not in this discussion.
Right.
Something I'd like to take up with you in the future, perhaps. I did find it highly interesting when you went to the sources of inspiration for this concept of human dignity with the religion question and all of that. And when you wrapped up and said, for lawyers, what's interesting is the principle and not exactly the source. That was more intellectual discussion. I found that interesting because I'm not a lawyer, so that wrapping up of that concept was highly interesting for me. Yeah, very good to see you again and to listen to what the Malawian judiciary is doing. So yeah, thank you for being here.
Thank you. You're most welcome.
Okay, Judge, I wondered when you were describing your views about what has happened after the Gambi case, and for me, this relates to the wider question about judicial vindication.
Wait, you mean the Masangano case?
Yes, the Masangano case. Sorry. Yes, the Masangano case. Yes. What is the efficacy of judicial vindication of rights, especially in a context where the violation of rights is the norm rather than the exception? I mean, what chance the protection of human rights if we are to rely on judicial vindication?
Okay, I want to make sure that I get you right.
Yes.
You are looking at Masangano case, and the quick and definitive conclusion that I draw that I don't think there has been any compliance, and then asking what's the essence of bringing these claims to the courts at all? Is that in a sense what you are looking at?
Even beyond that, I mean, in a context where perhaps you see loads of violations.
Yes.
Yes. What is the point of bringing these cases to court when these violations are not the exception?
Right. Look, let me attempt to answer this in two facets. One, the facet specific to the Masangano case, that look, here was a clear judicial decision which effectively, when you look at circumstances, does not seem to have been complied with. It is, I think, one of the problems of an adversarial litigation system where a court is laid back and it basically has to wait to be moved. It would have been interesting if there was a situation where the litigants came back to court and said, look, you gave a clear decision, clear timelines, and there has been non-compliance. What are the consequences? But as far as I know, that never happened. But I would think that it is something that ought to have happened, so that the courts would probably have, again, carefully thought through this and say that in this scenario, then what should we do in order to give effect to the rights? Because Section 46 makes it clear where there is a violation, the court must fashion an effective remedy. So I think the courts should have probably been moved to, think out, to think around these issues and decide what would be the consequential, consequential orders or directions. Where you have a situation of pervasive violations of rights, what's the point of bringing litigation drop by drop? I think in essence that's what you're asking. And
yes, it's a very unfair question, but I have to ask.
I would like to now I'm trying to recall what my professor Christoph Haynes taught me in my first lecture in the LLM program in Pretoria years ago. So he took us through, probably you as well, what he termed the struggle approach to human rights. And that keeps on resonating in my mind, that if we embrace this concept, that look, rights are almost never given to us on a silver platter. You have to fight for them. And so for me, as they say that a journey of 1,000 miles starts with the first step. So one should not look at how long the journey is and say, what's the point of starting? I am not going to walk to Nairobi. No, start and then see, before you know it, you would have gone as far as Dar es Salaam.
Yes.
So I would say that when one embraces this struggle approach to human rights, one should not relate even if it means, fighting for the rights drop by drop. For every victory, that's a step forward. And you're not going backwards. So I would say, let's, those who want to vindicate the rights through judicial actions, let them keep on with it.
Okay. All right. No, we have detained you long enough, and it's really a proud moment for me personally, but also for my colleagues here at Bayreuth, to welcome you here, and we look forward to collaborating in the future. You've had a long day, and I think we should let you go now. And yes, thank you so much.
Thank you, and it was also a pleasure for me. Thank you very much for inviting me for this. It was stimulating to my mind. It's been a little while, maybe a few months since I last seriously academically engaged. So it's good that you drew me back to scholarship. I thank you. Yes.
Thank you, Judge. Thank you. Okay.
Thanks. Bye.